Yeah, thank you so much for this introduction, Anton. And indeed, my presentation is about transparency issues of a specific financial application called Robo Advice. And so what is Robo Advice in a nutshell? Well, literally, it means advice by a robot. This is, however, not quite right, actually, because generally it is about a robot who is making investment decisions on behalf of a client, not just advising a client. So in other words, this robot is managing a portfolio. How does this work? Very simplified. Generally, the process starts with a client assessment, so an online questionnaire, which is about the investment goals of a client, about the previous financial knowledge, and also especially the risk tolerance. Now, based on the responses to this questionnaire, the robot, or in other words, an algorithm, then constructs an investment portfolio, which comprises different financial products and instruments, and is based on some finance model. Now, usually only after that, you then have to register to actually enter into a contract with the service provider and to let him implement this proposal. Now, if you do so, the actual robo-investing starts, which is basically about another algorithm, which is continuously monitoring this portfolio, and as the market moves up and down, is making sell and buy decisions. So ultimately, the long-term return of this portfolio is improved. This is also sometimes called rebalancing or risk management. Now, what about AI and machine learning? There are indeed some robo-advisors on the market who already today claim to use intelligent algorithms, AI, machine learning, and this concerns both the customer onboarding process, which I showed you, as well as sometimes the ongoing management. Now, generally, I'm quite skeptical whether this is overall, well, it's implemented on a broad scale. And this also suggests, for instance, recent work by Better Finance, a Brussels-based organization, which indeed looked whether robo-advisors are sufficiently intelligent to do this, and came to the conclusion that, well, basically it's a far cry from AI, so rule-based systems are in use. So what, in my view, however, justifies my then kind of forward-looking approach is that obviously everyone is talking about AI and machine learning also in the robo-advice space, and the regulators are looking at it. And most notably, the international standard setter for securities markets, the so-called IOSCO, they already last year in September published guidance, which is directed on the competent authorities in the different states, including Austria and Germany, for instance, and argued for some measures. And one of those measures was that literally regulators should consider requiring firms to disclose indeed meaningful information to customers and clients around AI and machine learning that impacts them. So the goal of my following presentation is to look at this primarily from a normative perspective on the existing EU legal framework, and in doing so, at least attempt to analyze whether we do already have meaningful information or whether we should make some changes maybe. So what is the overall legal framework? And well, from a finance law perspective, the key legislation is certainly the so-called MiFID II. We already heard this by Christopher. And specifically, this Markets in Financial Instruments Directive has two articles which are relevant for transparency issues, which I will zoom into on the next slides. But before doing this, just an overview of the potential other applicable or relevant legal acts, and specifically what is certainly also relevant but not covered by myself, the private law side, and specifically the contractual information duties which might arise in the relationship robo-advisor and customer. Then certainly also an interesting question, not covered by myself, but maybe some link to the next session, the data protection regime, and specifically the question whether at least some aspect of this robo-advising constitutes an automated decision-making. And while I'm not going to talk about this in detail, I'd just like to note here that there is indeed some discussion whether robo-advising constitutes an Article 22 activity, but in general, it is quite unclear. And also in practice, it seems like there are a few robo-advisors who say this onboarding might be ADM, but then you find a lot of robo-advisors who claim to not do ADM under Article 22. But maybe something to pick up in the discussion. And last but not least, potentially relevant in the future, the proposed AI Act. We heard already about this. And this is presumably, however, also not too relevant for robo-advising, because at least the provisions governing high-risk systems should not be applicable to investment services, contrary to, for instance, credit scoring or insurance aspects. So the focus is certainly then on the MiFID II. And here I'd like to start with this establishment of the client profile and the so-called suitability assessment. And the provision relevant is here Article 25 MiFID II, which first and foremost has this duty to collect indeed information first and foremost from the client to then provide a suitable advice. And this concerns the issues I already showed you in a nutshell on this questionnaire, the client's knowledge, the financial situation, and the goals and risk tolerance. Now, in collecting this information, there's certainly already some implicit information provision to the client, because in asking those questions, there will be some information. What we do also have is some explicit information provision under Article 25. And to be precise, this is not set out in the MiFID II, but actually what we call in finance law the level 2 commission delegated regulation, which supplements this Article 25. And specifically under Article 54, we have an explicit duty to inform the client, the potential client, about the purpose of this suitability assessment. And now the interesting aspect is that, again, this provision has been clarified at the so-called level 3, which is not hard law, but quasi-regulatory requirements, which are guidelines by the European Securities and Markets Authority, which were issued and revised in 2018 to actually take into account robo-advising. So briefly, what is now required under those quasi-regulatory requirements? It is set out that robo-advisors should first very clearly explain the exact degree and extent of human involvement. Furthermore, they should describe the sources of information used then to provide this portfolio management service, and a special emphasis is put on this online questionnaire. Now, thinking actually about AI and machine learning, this is, in my view, raising some questions, like under the first point, if you explain the human involvement, there seems to be a high chance that you at least implicitly need to communicate about the presence of AI. And I think even more tricky is the second point, that the informational sources used in the portfolio management. If you really have a sophisticated machine learning model, not only using the questionnaire or the responses, then this also should be disclosed to the customer. Now, this is the first leg of the information regulation I wanted to present you, that the precise provisions for the information to clients is actually set out in Article 24 MiFID II. And before going into the substance of this provision, I want to stress that under this leg, we actually don't have such guidelines who clarify specific information duties, not on the level 3 and also not on the level 2. And while this is not surprising at first sight, actually, if you take a little bit a comparative approach, it seems like the EU is not following the international approach. Specifically, I'd like to note the US situation. that the US Securities and Exchange Commission already 2017, and this has been reiterated in 2021, do require some specific information to clients. And just one, I think, very relevant part of this guidance, one has to describe the assumptions and limitations of the algorithm and also the finance model, which is underlying those assumptions. In this case, it's the so-called modern portfolio theory. The same is, for instance, true also in Singapore. Now, I mentioned we don't have something like that in the EU, which is why the overall discussion has revolved around, indeed, the very general provision, Article 24. Now, looking into this Article 24, which has been indeed at the heart of the debate, specifically paragraph 4 and 5 are relevant. So under those general information duties, a firm, including a robo-advisor, has to provide appropriate information on a number of topics. And one of the subjects is the firm itself, the robo-advisor, and then also its services. And now the rationale of this information provision is, according to the law, to enable the customer to understand the nature and risks of the service, and ultimately to make an informed decision. What is also set out already in the MiFID II level, how this information provision has to be provided. First, this needs to be done in good time, meaning pre-contractually. It also needs to be done in a comprehensible way. And last but not least, if the member states allows it, this can be done in a standardized format. And so what is precisely understood by appropriate information is here again fleshed out at the so-called level 2. Now, we don't have robo-advising specific requirements under level 2, which is why the overall discussion revolved indeed around this very general provision you see on the slide. Now, what is kind of the status quo of the discussion in the literature? There are apparently more voices actually in favor of some sort of robo-advising specific disclosure. And while they may differ in nuances, in general, under those voices you can see on the slide, it is well argued that you should at least disclose the use of algos, of AI, and additionally, the basic functioning of the systems. And sometimes you also read that the limitations need to be disclosed, the risks, etc. There are indeed some voices who are, I think, opposing this view, who are against such a robo-advising specific standard. But the prevailing opinion seems to be actually in favor of some sort of AI or algo transparency. Now, in my view, there are indeed some open legal issues, which I will not dive into right now. I'd just like to emphasize the issue of information overload. If we indeed require disclosure, it certainly has to be balanced, that it's not actually an information overload for the client to make then an informed decision. And there are then also some questions with regard to the so-called principle of technology neutrality, which is about the relationship of traditional investment managers and robo-advisors, because maybe also traditional investment managers use algos in their ongoing management, and until now nobody claimed that they should kind of explain those basic functioning or the basic functionalities. Overall, but looking at the purpose of this provision, I do think that better arguments are in favor of some, well, rudimentary information, at least to make an informed decision. And because relying on this very general provision, it's certainly very much in the margin of discretion of the firm how to do this. Now, so some rudimentary information, at least in my view, that there's still one small caveat, which is precisely Article 24, paragraph 3, which not itself requires some content to be disclosed to the firm, but actually sets out a standard which all communications, all information which is provided to potential clients need to adhere. And specifically, we have this overarching principle that one always has to provide fair, clear, and not misleading information. Again, this is fleshed out at the so-called level 2, but I will not dive into this right now. Now, thinking about AI and machine learning again, there are indeed some issues in my view. Specifically, if you today claim to use AI, then in my view, there will be a duty to explain it also from this perspective, at least the basics, because otherwise there's a high chance, in my view, that this is unclear because of the ambiguity that the notion of AI has. Now, there's certainly a balancing again required, because too much information to the average investor is in the end also not understandable. So balancing again is an important point here. Now, with this, basically, I'd also like to come to my kind of conclusion and my assessment of meaningful information. And so overall, I do think there's not too much information today required by the finance law side. And this might prompt the question, do we need something new guidelines, new approaches to have actually meaningful, more information? And in my view, probably no. And to kind of substantiate this, I'd just like to end with the overall rationales of transparency in the finance context. And to some extent, we already discussed this certainly in more detail yesterday. Like on the one side, it's certainly about enabling customers to make an informed decision. Equally important, in my view, the issue of trust, of confidence, which is certainly also prominently discussed in the AI discourse, and specifically here in regards to AI services on the capital markets and markets as a whole. And I think certainly also from a practical perspective, very important, the issue of the enforcement of the clients, the investor rights, if there is some wrongdoing, if there are some, well, wrong decisions. Now, these are certainly valid rationales in my view, although they also need to be balanced, as I already partially mentioned. I already pointed to the issue of information overload. Yesterday, we heard with regards to the issue of trust, also this very important aspect of algorithm aversion, specifically the behavioral insights that maybe too much or even information as such is not so helpful in this context to address this algorithm aversion. And last but not least, with regards to the enforcement of the client rights, there might be other preferable options, like already argued in the literature, thinking about the civil procedural aspects, or, and I do think this might be worth exploring, to actually, well, enhance the interplay between the supervisory scrutiny, who are the experts who can look into the actual, well, models if they want to, and then building up on the supervisory knowledge, the private enforcement. But this is certainly open for debate, and I do look forward to do this now with you, and thank you very much for your attention.